Okay, I'd like to call this meeting to order. This is a meeting of the Huntington Township Zoning Hearing Board. My name's Dave Reinecker and I'm the board's chairperson. The other member of the board sitting next to me is Tom Hart, and our other board member, Doug Spielman, was not able to attend this evening's meeting. Because this is a three-person board, we only need two members to be present to have a quorum. With two of us present, we do have a quorum. The board solicitor is Mr. Matt Teeter, who's sitting to my right. Our stenographer is Deb Zepp, who's also to my right, is also here with us. Thanks, Deb. We usually begin these meetings with the Pledge of Allegiance, so I'd ask you to please stand as you're able. The purpose of this hearing is to consider the application of Timothy J. Spangler and Lisa Spangler relating to a property known as 300 Mud Run Road, York Springs, Pennsylvania 17372. It is the Adams County tax parcel number 22106-0010-000. The property is in the Agricultural Conservation AC zoning district. The applicants propose to subdivide the property to create 3 lots, which with new single-family detached dwellings to be constructed on 2 of the newly created lots. The applicants seek a variance from section 27505 of the Huntington Township zoning ordinance to permit the 2 lots upon which the new dwellings would be constructed to exceed the 2-acre maximum permitted in the district. Both of said lots will remain in agricultural use. I'm going to identify the parties. The applicant, Timothy J. Spangler and Lisa Spangler. You're both here. Thank you. Counsel, Michael, is it Paisha? Paikosh. Engineer, Doug Bream. Is Doug here? Back there. Are there any others present with the applicant?
No, sir.
Please identify yourself, okay? Huntington Township, Solicitor Todd King. Is he here? Do not see him. Zoning Officer Scott Longstreet.
Here.
Scott. Identify other parties of interest. They may be referred to as objectors. And I request that any party or parties to identify themselves for the record by providing your name and street address. You decide whether to identify party has standing to be the party.
That's just a note for you. So we're just gonna say, is anybody here to object to the application that would like to be a party to the proceedings?
Please stand and state your name and your address, please.
Robert Van Kallenberg, 388 Fixes School Road.
Sir, I have an entry of appearance form that I'd like you to have you fill out with your information. And then whenever we'll get to you, whenever it's done, just bring it back up to me.
And someone else?
Yeah, I need a little more definition. My name's Rob Van Bleek from 565 Mud Run Road, and I did a subdivision 10 years ago and had to abide by the 2-acre rule. I guess my question is, if this is allowed to go forward, am I allowed to ask for rezoning and get my acreage increased for the same process?
This hearing is not for rezoning, it's for a variance from the requirement.
Right, and I had the same, I subdivided, had to go lower.
So we're not gonna address past issues or make any decisions on any other properties in this hearing.
Okay.
This is solely on this application. Are you objecting to this application?
I'm not sure what the difference is yet, so I'm waiting to see what the variance change will be.
Well, if you decide to speak to this issue, you would need to state your name and your address and be registered as a party.
Understood.
Okay.
Could we just make a decision here on the, sir, I wasn't able to understand your name when you stood up in your address. Could you state that again? The first?
Address.
388 Fixes School Road.
Ficus.
That's in close proximity,
That's, yeah, that's a neighbor.
right? We usually encourage the board to be fairly liberal in permitting parties in interest who have properties in close proximity to allow a party to have standing. If you'd like to do so, if there's two of you, you can, I don't know that we need a formal motion or anything, but,
I have no objection. I have no objection to that one.
okay. So he will be admitted as party. He'll fill out his form and he'll be permitted to ask questions of witnesses and provide his own testimony. We'll just have to make sure that he's sworn in as part of the later part of that, which is the next step.
Okay. Ms. Donfer, would you please swear in all parties?
Anyone who's going to testify, please raise your hands.
Raise your right hand. You're going to be sworn in.
Oh,
Do you swear and or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
yes.
Okay, thank you.
Okay. The outline for the proceedings for our hearing.
Okay, I'll just go over it briefly since we have a number of people here. Everyone who has been identified as party or witness has been sworn in will be permitted to testify. If anybody ends up testifying that hasn't been sworn in, or giving, we'll get them sworn in before they give any testimony. A verbatim transcript of this hearing is being taken by our stenographer. Please don't speak over one another. We'll give everybody time to speak when it's their turn. Although this is a hearing, formal rules of evidence do not apply, but we'll try to limit irrelevant, immaterial, or unduly repetitious evidence, and the board can exclude that. We just want to keep things moving along in an orderly fashion. Each party or their counsel may cross-examine each adverse witness. Cross-examination of an adverse witness should be in the form of a question. Cross-examination of an adverse witness is the time to ask these questions of the adverse witness about their testimony, and is not a time to present, for the person asking the question to present their own testimony. So if there's an objector present, if the party is giving testimony, it isn't the time for the objector to state their own opinions about the matter. They'll have a later time to present their own testimony. It's just for questions, so that's cross-examination. The board may also, or me as a solicitor, may also ask questions of each witness who testifies. We'll have the zoning officer give some background if there's anything that wasn't in the notices or anything, if he'd like to start, but then the applicant will present its case first, their case first. Then the township would present its case, and that would just be if our zoning officer has anything to present after the applicant's case is presented. And then last, each objector will go in order one at a time and present any testimony or evidence that they wish to present. And again, the objectors will be subject to cross-examination by the applicant, by the board, and other parties. After everybody has presented their case in chief, we may have time for any party to present rebuttal testimony and evidence if necessary. And then if anybody wants to, they can present concluding remarks or closing arguments. At the conclusion of all testimony and closing arguments, the board may adjourn and go into executive session to deliberate, which is permitted by Pennsylvania Sunshine Act. Following those deliberations, the board will return to public session, go back on the record, and typically this board, with a few exceptions, will render its decision immediately after its deliberations tonight. If not, there would be a separate meeting scheduled to deliver its decision. And then that date would be announced tonight. Then the board will issue a written opinion, and that will be mailed to all parties. All parties, after receiving the written decision, are permitted to appeal the decision if it's adverse to them to the Court of Common Pleas. Party who desires to appeal a decision of the zoning hearing board should seek advice and assistance from legal counsel. They're certainly permitted to appeal pro se without an attorney, but it's always best if you're going to appeal something like this to have have counsel. And I'll just, if it's okay with the chair here, I will just jump into the next item. And that is just to give some information about the notices and confirm notices and give everybody a copy of those. Is that okay?
Yeah, that's fine.
I have a copy of all the notices and some information about when notices were sent out here, and I'll provide a copy to all the parties. I have proof of publication in the Gettysburg Times. Notice of this hearing was published on July 2nd and July 8th. I have a copy of the notice mailed to the applicants on June 30th. Copy to our zoning officer, copy to the applicant's counsel and their engineer, and copy to the township. I also have a copy of the notice sent to the owners of adjacent properties that was mailed on the same day, June 30th. Our zoning officer alerted me to the fact that I missed one of the surrounding property owners. That was Trent and Stephanie Miller. So I subsequently sent a notice to them that's in this packet. That letter is dated July 2nd, 2026. I was leaving for vacation. I was on vacation last week and a little bit of the week before that over the holiday weekend. And my secretary I found on the Monday the 6th the envelope with postage, and so even though it's dated July 2nd, it actually was not mailed out until July 6th, I believe, to Trent Miller and Stephanie Miller, who I think are next door neighbors of the applicants. Last, and our zoning officer can confirm this, but he posted the property. There's a picture of the notice that was posted on the property on July 7th at 1:50 p.m. It was posted on both sides of Mud Run Road, and we have pictures of those notices attached as part of this packet. Do you have any questions about that? Okay, I'll give copies of this. I'll give you a copy of that too. And can you confirm that the notice that's pictured there was posted on July 7th, 2026? And that those are the pictures that you took after posting the notice on the property?
Yes, that's correct.
Okay. All right.
Okay. Next is Scott, your recommendations.
Well, really, that would be, I apologize, I took this outline that I gave to you from another thing where we could have had planning commission comments or recommendations, which we probably don't have here in the variance, but it's just any background really at this point, and then, you know, a subsequent opportunity to present.
I think the applicant can accurately present his case, and I can fill in
Okay.
if there's anything that's, I think is missing.
Okay, then we have the presentation of the applicant's case.
Thank you. As was indicated, my name is Mike Pykosh. I'm an attorney representing Mr. and Mrs. Spangler this evening before this board. Most of the testimony is going to be by Mr. Spangler. So, Mr. Spangler, just for the record, could you state your name?
Timothy J. Spangler, but I would prefer you just call me Tim.
Okay. And are you and your wife Lisa the owner of 300 Mud Road?
Yes, that is correct.
Okay. But where do you currently live?
Currently, we live in Strabane Township on Zepp Road, 55 Zepp Road, and I've been there 29 years.
Okay. And is that property on Zepp Road in conjunction with the family farm?
Yes, it is. Historically, our children would be the 5th generation at that farm, and my grandfather had farmed it, and then my father farmed it, and then myself and my brothers farmed it. We had some small grain, corn, and obviously livestock, which is my passion, and our kids. So our kids would have grew up there as well. Our 6 children, and 5 of them would have shown in the 4-H program, just like I did since I was 8 years old. We would have shown here locally in the county every year. And my daughter, and I took her nationally to Junior Hereford a couple years. If anyone knows Darlene Resch, I gave her about 50% of her gray hair that she has when I was a teen. And that, I think that history is sort of what we're looking at here as a family farm, that I could have our children close to us and pass on, live here in the neighborhood, continue to farm the land, whether that's crops. Right now it's currently in corn, and it continues to be farmed. It's also in clean and green. And so our goal, I think, with the history of our family, would continue on this property.
Thank you. So I want to show you what we have pre-marked as Exhibit A1. Do you recognize this as the application relative to this dimensional variance request with respect to the property at 300 Mud Run Road?
Yes, sir, that's correct.
Okay. And so you prepared this application, is this correct?
That is correct.
Okay. And the information on this application is information that you provided, is that correct?
That is correct.
Okay. And then I'm going to show you, I handed out Exhibit A2, which is a map, but I'm going to show one here that we could sort of take a look at while we describe the property in question. First of all, how many acres is 300 Mud Run Road?
Currently, it's a tract of 50 acres.
Okay. Does it currently have crops on it, any part of it?
Yes, there would be 25 to 28 acres on the south side of Mud Run, and then there's about 17 acres of corn. Well, maybe not quite 16 acres of corn, maybe on the north side, roughly.
Okay. And the north side is where it's marked proposed lot 2,
That is correct.
right? And the south is proposed lot 3.
Yes, sir.
Okay. And would you agree with me that this property is unique for the fact that it is naturally divided by Mud Run Road?
Yes, there would be about 20% on one side and 80% on the other side of Mud Run Road.
Okay. And so this subdivision, ultimately, if you get zoning relief here, proposes 3 lots, is that correct?
That is correct.
Okay. So we heard earlier on the explanation where a lot for residents has to be greater than 1.5 acres, but not more than 2 acres. Is that correct?
That is correct.
Okay, so lot 1 is a lot that you would like to create, but that's where an existing structure exists. Is that correct?
That's correct. That's the farmhouse existing now.
Okay. Now that lot is greater than 1.5 acres, but less than 2 acres. Is that correct?
That's correct.
In fact, it's the net acreage on that is 1.99 acres. Is that correct?
Yes, sir.
Okay. Lot 2 is a lot that.
Excuse me, can I interrupt you for a moment?
Sure.
I'd like to clarify that these are proposed lots, they're not current lots.
Right.
Yes, sir.
Yeah, they're proposed. Yep. They're all proposed. That's what the document says too. They're all proposed there. We looked at the zoning ordinance for a property of 50 acres or more. The zoning ordinance would allow 4 lots. Is that correct? Is that
Yes.
your understanding?
Of the chart, yes.
Okay. But is it also my understanding that in the future, you're not going to be looking at any further subdividing at all?
That's correct.
Okay. So let's go back to the proposed lot 2. Proposed lot 2 as we see on the chart, has 16.33 net acres. And that's obviously above the 2-acre maximum.
That's correct.
Okay. So, and for the agricultural zoning district, you would need a dimensional variance for lot 2.
Yes.
Yeah. And same for lot 3. Lot 3 has 30.77 net acres, which is above the 2-acre maximum. Again, in the AC zoning district, we're asking for lot 3, a dimensional variance. Is that right?
That is correct.
Okay. Now, in your application, you had indicated that for lots 2 and lot 3, the homes, probably the curtilage around it, would not take up more than, would be less than 5% of those respective lot
That
areas.
is correct.
Okay, all right. And so the idea would be the remaining amount of acreage in proposed lot 2 and proposed lot 3 would be used for what?
Agricultural use.
Okay. When you say agricultural use, tell me specifically what we use it for.
I would say corn and soybeans at this current time with the farmer that's farming it. We do also have some sheep on it currently that we're raising. And at some point, my passion would be that if we have grandchildren someday, to have maybe some livestock on it as well.
Okay. We previously talked about Mud Run Road, this lot, the 50-acre lot is unique because it's divided by Mud Run Road. Are there any other unique characteristics of this property that you'd like to point out for the board?
On the northwest corner, there is several acres of trees, brush, and foliage and whatnot that probably are in the lowest portion of this 50 acres. There's also maybe a half acre to an acre on the southwest corner as well of partially wooded area next to the Geist property there.
Okay. And the way you have these proposed lots set forth here, with being higher acreage than the maximum, was the idea to maximize the amount of agricultural land that would be left over after the lots were divided?
Yes, we want the minimal impact as possible with the building of Lisa and myself's home and possibly another family member down the road sometime on the north side, so that we would minimize any impact or limit the impact of building, and the rest would continue to be farmed as much as possible or in agricultural use.
Okay, so you just explained, one of the lots you were going to have, you and your wife Lisa, you have your home there.
Yeah.
What lot were you thinking?
That would be lot 3.
Okay. And then what would be the use of lot 1, the existing?
Lot 1 with the existing home is where our daughter and her husband live currently, and they would own that lot.
Okay, and lot 2, you have some other children, right?
Correct.
So what do you propose for lot 2? Is that a lot?
At some point in time, if the Lord would have it, that he would be able or she would be able to build there and have a family farm and homestead in this particular 50 acres total.
Okay. And your children, you explained that you grew up in a farming family. Have they been exposed to being a farming family also?
Yes, all of my children raked hay, cut hay, baled hay, showed cattle, showed goats, showed hogs. They've all been, grew up on our family farm and was involved in crops and livestock and the operations of agriculture.
Okay. And we previously spoke about the unique feature of Mud Run Road, and you outlined some wooded area on the lot. Do you have some issue with regards to perk and probe on the property also?
Yeah, I mean, we identified 2 areas, one on lot 2 and one on lot 3 that would be suitable probe-wise for a septic system, an on-lot system. We also probed many other areas, whether it was on the south side or the north side of Mud Run. And literally, I think the property has an indigenous limitation that unless the township would decide to build and provide public sewer and water, there's no other place really that would have a perk and a probe approved in the soil. So these are the only 2 locations that we would ever propose to build on.
And as you indicated earlier, you wouldn't in the future be proposing any type of subdivision for any other homesteads on these properties?
No, sir, this is the way that it would stay.
Okay. I want to, just for purposes of the character of the neighborhood, go through just the surrounding properties. If you could describe, first of all, you're familiar with the surrounding properties?
Yes,
Right.
I actually visited all the connecting properties a couple weeks ago.
Okay. So let's start over to the north. There's the Geist Dynasty Real Estate. It's marked up there on the gate. Could you tell me what that is?
It looks like it's in agriculture. There's crops and farmland. There's a few houses along the road, but mostly agriculture.
Okay. And then to the west, there's the Trenton Stephanie Miller lot. Could you tell me what features are on that lot?
Yeah, that's, I forget how many acres, but it's mostly open pasture with beef cattle in it, and they have a single-family residence there on the property as well.
Okay. And to the south of the Miller property, west of your property, is the Matthew P. Geist property.
That's correct.
What is any?
It's in, I think, 95% wooded, as far as I can tell. Almost all wooded, and there's a single-family home located on that property as well.
Okay. And then to the south of your property, I don't think it's marked with the owner there.
No, I think that's Mr. Meredith, Robert Meredith, and that's an agricultural farm with a single-family home and outbuildings as well.
Okay. And then to the east, southeast, there's
The Hermanson,
and Sons property.
correct.
What's on the property?
That is crops right now.
And above that,
Would be Kurt and Maggie Hermanson. It has a single-family house on it, and it's probably partially farmed as well with crops. I don't know where the line is out in the field, but
and above that, there's the Myers.
Daniel and Don Myers, yes, had a single-family home on it, some outbuildings, and then just some open grass field in the rear.
And then next to it, to the east of the Myers.
Another Hermanson and Sons property, I'm pretty sure that's being farmed with some crops on it. I don't remember exactly what's in it, whether it's corn, beans, or hay, but there's crops on that.
Okay, so essentially, obviously, because this is in agricultural conservation district. There are some single-family homes, but mostly agricultural.
That's correct.
Right. And, one of the purposes of the agricultural conservation district is to preserve agricultural land. And they want to make sure, there's not houses there that would create extra litter. I think the ordinance said that it's not going to create traffic that would impede farm operation machinery. Do you envision these lots that you're proposing to create to any way interfere with the spirit of the agricultural community within the agricultural conservation district?
No, if anyone has driven by since we purchased the property, we have cleaned up a good bit of the property and hopefully have less litter, if anything, and we would not be big users of a lot of equipment, just what would be necessary to farm it and keep it in agriculture use.
You're not going to have an inordinate amount of cars and trucks that are going to...
No, this would be a strictly residential use.
So, some of the requirements, this is a dimensional variance, which is, different from a use variance. But one of the requirements of the variance is that the property has to suffer from unique physical circumstances or conditions. Could be topographical and such. Is it your position that the division of Mud Run Road is a unique characteristic and the main reason why the division is as it is?
Yeah, I think it's unique in that it's the natural division of the land and property currently already. So we're not really changing the character of the land. We're using a natural division that already exists and will continue to exist.
Okay. And then also that because of such physical circumstances, there's not a possibility that can be developed in strict conformity with the provisions of the chapter. Is this, the way it's divided, is it your position that because of Mud Run Road and dividing the property as it is, that this plan would be the most efficient way to divide this property to preserve as much agriculture on this lot as possible?
That would be correct.
And that's why you chose how to divide this lot?
That's correct, yes.
And
Our goal is to keep it as much as agriculture and as much as it currently stands as possible.
Another requirement of the variance is that the hardship was not created by the applicant. And obviously, when you purchased the property, this is actually one lot, is that correct?
That is correct.
And it's divided by the road there.
Correct.
And that the variance, if this board would grant it, would not alter the essential character of the neighborhood or the area.
No, I think it would actually fit well with the character of the neighborhood and what is currently surrounding each corner of the property. With the road being the division line, it's already currently that. With any single-family residential home would be less than 5% of each tract. So I think as we look at the neighboring tracts of land too, it goes along with the family farm, the homestead, grandpa deeding land to the children and passing it on through generations.
And then finally, another factor for a variance is that if it's authorized by this board, it would represent the minimum variance that would afford relief. And I think you testified to this before, that this proposal, the way it's divided, would essentially keep the agricultural, most of the agricultural features intact and maximize the features.
That is correct.
Because of the divided road.
The divided road and where the probe and septic would be for each lot is at the edge, where it would really not impede on being able to farm or make it harder to till or plant or have agricultural activities going on there.
The board could just indulge me for one moment. I just want to.
Do you have a plot with where your probe would pass?
Would you like me to show you on there?
Yeah, if possible.
It's marked. So these 6 flags here would be for lot 3, and these 4 probes here would be the square footage required for lot 2.
I can speak to that when they're done.
So, Mr. Spangler, section 27502, and we looked at this also, speaks of the legislative intent of the agricultural conservation district, and that the legislative intent was to protect and stabilize agriculture in the area, productive soils, permit only those land uses and activities that are agriculturally in nature and incidental there too. We do say that a house on a family farm would be incidental to a farm.
Yes,
Is
that's
your
correct.
intent to not only preserve the agricultural nature of this plot of land, but also to preserve the concept of the family farm?
Yes, and homestead, yes.
And again, we talked about this earlier, that the legislative intent also wants to decrease, not have an increase in traffic on the roads, so that farmers could move machinery and livestock. There's not a contribution of additional litter or nuisance that would in any way endanger livestock or cause damage and loss of crops. Do you believe that your proposal would adhere to the legislative intent of the ordinance?
Yes, I believe 100% of that.
Okay. I don't have any questions at this point for Mr. Spangler.
Okay. Scott, do you want to present your side?
Well, let's ask, does the board have any questions for the witness? I have one question for the witness or
Go ahead.
counsel. Do you have the, and maybe you said this and I missed it, what portion of tract or proposed lot 2 and proposed lot 3 would be set apart for the residential use versus?
Well, it would be near the location of the septic.
So these are the probes down here
Yeah,
for this lot and up here. And Mr. Spangler testified that the home and curtilage for the home would take up less than 5% of each of the respective lots.
Would it be less than 2 acres?
No, I think that's part of the
Is that, I guess that's what I'm trying to.
hardship here is because of the poor soil, it's a pretty sizable square footage, which is what the soil scientist uses, is the square footage of the area to make up the septic system, which would cover about an acre, maybe a little bit more.
So I'm gonna have Mr. Brown testify as to how the sewage disposal will work and the area that would be needed
Okay.
also.
Any other questions?
No.
Tom, do you have any questions? I do not.
So this would be the time if the township, and perhaps the township, if he had any questions of the witness, but
Okay.
let the applicant finish with their witnesses before Scott would actually present any of his own testimony.
Okay, do you have anything else?
I'm gonna have Mr. Brown
Okay,
testify. Scoot up here. Mr. Brown, could you, again, state your name for the record?
Douglas Brown, Brown-Lebo Engineering, 17 State Avenue, Carlisle.
And Mr. Brown, what is your profession?
I'm a professional land surveyor, and I got like two degrees from Penn State in engineering and land surveying, but I'm a licensed land surveyor.
Okay. And how long have you been practicing?
45 years.
And I know I've seen you in the township meetings, but you regularly testify as an expert in township meetings, correct?
Probably hundreds of times.
And you were hired by Mr. and Mrs. Spangler to create this proposed subdivision plan for 300 Mud Run, is that correct?
Correct.
Now, you heard the testimony of Mr. Spangler, his characterization of the proposed lots and the surrounding area. Do you agree with all of this testimony?
I do.
Okay. Is there anything that you don't agree with?
I don't.
Okay.
No. I have a few things to add, but nothing I disagree with.
Okay. So the solicitor had asked some questions about the way sewage would be disposed of along these 2 lots. And I think it's sort of unique. So do you want to let the board know how that would take place?
Sure. So I wasn't involved in the testing, but Tim scheduled that with the township SEO. Let me just back up the steps. What our firm did to get to this point was a complete survey of the property. The boundaries are accurate. The depiction of the roadway, existing buildings, well, septic, and then also the locations of these test sites that the SEO did for Tim. Tim's correct. These systems are proposed to be fairly large. At a minimum, they're spray irrigation systems, which are unusual. I mean, not totally unusual, but you can't get a conventional system there. You can't get a sand mound there. And the third thing is spray irrigation. So your SEO determined that was appropriate. Each of those systems, they're both located in the back of the property. And he's suggesting that the drain field of the system will be at a minimum 20,000 square feet in size.
for each one?
Excuse me?
For each one?
For each one. That's right. When we received that information from Tim about where the testing was done and what the outcome was, we began to try to figure out how to subdivide 2-acre lots on here. The problem right out of the gate is they're well back off the road. You have to have road frontage. You can't have a flag lot. We explored that. But there's no way to get the bed in here, the home, maybe an outbuilding because he does want to do some ag on the property, and then get a well location on here on 2 acres. You're probably, and the other variable, which isn't spoken about here much, but it is in your ordinance, there was no provisions for a backup system test done. So if you leave a little room for that option, you're looking at lots that are going to be up over 6-8 acres or so in order to get everything to fit on there. So your ordinance seems to suggest that you have a minimum lot size and a maximum under section 27505. But it also talks about having to meet DEP requirements, which is what this testing is all about. And what we found in a lot of the maximum lot size ordinances in different townships, if the testing was approved for an area, say like that, I got one here and one there, you can draw your lot line out around that. You can go over the acreage in order to meet the DEP requirements. So that's kind of what's happening here. If the testing would have been done up close to the road, we could have this is 2 acres right here, just to give you some perspective. I don't even know how you fit, but for instance, right here, this is the size of the box that's got to contain that system. That's going to cover that property right there. So there's no way you can meet the 2 acres because of that.
Is the septic system currently on proposed lot 1, is that a sand mound?
I'm not
I
sure.
believe it's conventional.
It's conventional.
I believe it's been there a while.
It's been there,
Long time.
yeah.
Okay.
Right. So, is there anything unusual or unique about the property? The property's got limitations. It's got poor soils, and he's only got 2 options for septic locations. So, and being that, if you tried to make this work with a larger lot, it's going to get to the point where it's going to be so large that, in all practicality, why would we just use half of this? You know, if he's going to do the ag use on the property, it just seems to make more sense to keep it all in one ownership, and instead of creating a lot here, have a remainder or whatever, and chop this up, I think, even worse than what we're proposing to do. So we didn't really explore that far. I mean, we're just trying to get through this part before we start spending his money doing a subdivision plan and all that other stuff. So, but yeah, the DEP requirements and the SEO requirements really kind of put him in a corner here, as far as that goes. Let's see if I have anything else here. The field's relatively flat. I feel kind of embarrassed to say this, but I've looked through the ordinance and I'm not sure I saw a definition for agriculture or farm. Is there a minimum lot size for a farm in your township?
Minimum lot size, no.
And so I didn't think so, and there usually isn't. So I guess a question I would have, and maybe to Tim's point about the farming, is what constitutes a farm? Most farms have a single family home on them, and barns and buildings and whatever. But in your mind, it's 100 acres or whatever, 50, 200, larger. Without a definition of what that is, I'm not sure that what he's proposing doesn't meet what you're looking for. A single family home in an agricultural zoning district that's going to be, there's people going to be living here, but they're going to farm it like they are now. So, thanks for answering the question. The other thing that your ordinance talks about is a replacement septic system, which is pretty typical in most municipalities. And I don't believe they tested for a replacement.
The SEO, for whatever reason, didn't find it necessary, and obviously he could be wrong, but that's what he told me.
You mean on the proposed lot one?
Yeah,
Yeah, I remember you telling me
I
that.
think he was looking into DEP though, I'm not sure how far.
Yeah, so we might not even be done with that, maybe.
But he was convinced that we didn't need to. put
Okay.
one, But,
And my only point about that is, we represent 5 municipalities, our firm, so we're pretty familiar with both sides of how this works, and we require them. You guys have it in your ordinance, your SEO gets to make that call, but it would probably be prudent not to shrink these lots for the homes down just small enough to capture one system and whatnot. It'd be better to have the option to, if something like that with the system, to have more area to go test before the backup. That's the whole idea behind it anyway, so I guess I just wanted to make that point. Yeah. So that's about all I have to offer from
Okay.
a technical standpoint. Is there any questions you have?
Any questions? Okay. Tom?
I just wanted to clarify, and the township is working on a new zoning ordinance, and sometimes I have difficulties with this one, but my reading of it is that an agricultural use can include a farm dwelling, even in a subdivided lot that's to be developed. 2750 5B1 does talk about that the portion of an agricultural, I think, I read it to say that a portion of an agricultural lot that would be dedicated to the residential use on the lot should be limited to the maximum lot size for the residential use, which is 2 acres. So what I was trying to get at, and I guess this is maybe why the variance application was filed, but you said that the septic system would be 20,000 square feet, which is, I think, less than half an acre.
A little bit less.
And so you're saying that that septic system and the improvements for single-family residence will be more than 2 acres of the proposed lots?
Yes. I mean, I didn't mention the well's got to be 100 feet away from wherever the septic system ends up being. I don't know exactly how large the home would be. I just figured.
and then the setback.
And you got setbacks, and in the back of my mind, I'm thinking backup area for a second system. The distance off the road adds to the acreage, even if I do a panhandle.
As does proposed lot two. That's at the back of the lot as well.
Out there, right?
And you're gonna have a driveway.
Correct. Yeah, I mean, if I just went with a conventional lot, I think your minimum width's 150, something like that. Let's just say I did that.
Well, if you take 20,000 square feet off of 5% of 16.3 acres in your proposed lot two, you've only got 8.815 acres, and you're taking half of it for the septic. So you've only got 3/10 of an acre left for the driveway, the well, and the house, and that doesn't seem logical to me.
Oh, and
That doesn't meet the common sense criteria of this body.
with.
So I think your 5% is quite a bit less than what it's actually gonna be
Okay.
of that, at least of lot two. Of lot three, proposed lot three, you're into 1.54 acres there. Yeah, you could take a half acre for the septic and still have an acre for the driveway, but as you said, that driveway is gonna be back, that home is going to be, there's gonna be a fair driveway there on your property that's gonna take away from agricultural
Yeah,
land.
driveway, that could be 1,900.
Now, I'm gonna also play devil's advocate as a farmer. You could put a livestock gate out there at Mud Run Road, and you could have the driveway be part of a pasture system. They can pasture across a stone driveway, and the driveway is technically still part of the pasture. So, that's a possibility. It's not seen very much in this area, but it could be done.
I guess I'm just still confused, and I'm not at all suggesting that because perhaps you could fit a home and a septic system and a driveway on 2 acres, that this is not permitted under the ordinance. What I'm trying to say is, you said that less than 5% of each lot would be developed, which is less than 2 acres. So what I'm saying is, I think my reading of the ordinance is that a subdivision of lots into agricultural lots that include new single-family dwellings can exceed the 2 acres, but as the ordinance reads without a variance, the amount of those lots, which are agricultural lots that are 20, 30 acres, whatever they are, be 2 acres or less. When you say that the amount of land that you're going to develop is less than 5% of these lots, well, that would meet the ordinance in my interpretation of it, because that's less than 2 acres. But if you're saying that the septic system and the house would take up more than 2 acres, I think I'm just trying to nail down get a better idea, like what acreage we're talking about to fit that stuff on. Not at all in conjunction with suggesting that means that you would have to subdivide off a lot to that size, separate from the agricultural part of the lots. Does it make sense what I'm saying? You can subdivide a 100-acre lot into however many lots, and if they're all agricultural and they meet the number of lots based on the ordinance, you could put a dwelling on them. The ordinance just says that dwelling should make up less than 2 acres of the...
I think the intent, this is clustering. I've seen this in other municipalities where townships were frustrated over losing farmland. I'm from Carlisle, so it's all around there, South Middleton, Dickinson, all of them. And they came up with the same formula. It's pretty common. Maybe the numbers are different. And I've always felt like you're trying to overthink it a little bit too much, but I think the idea is if you're going to subdivide, which if you flip this over, right here, for example, just around the corner, if you're going to create single-family lots, that's what this is all about. That's what your ordinance is all about. You know, people were just chopping up road frontage over the years and losing farmland and whatnot. So the clustering was an attempt to limit development, so many lots per acreage per farm, and this is where you need to put them. This is different than that, in that he wants to build 2 homes on farmland and farm them. So he's not, so I don't know. I know why you wrote the ordinance, because so many other townships have, but I've always questioned, like, what if somebody comes along and wants a 50-acre farm or a 20-acre farm? Why can't you do that?
So just to clarify, so I understand here, Mr. Spangler indicated that less than 5% of each of the proposed lots 2 and 3 would be developed but that's not technically accurate. Is that? Go ahead, Mr. Spangler. I might be mischaracterizing.
I think I misrepresented that. I meant of the 50 acres.
Okay.
The 2 locations would be less than 5%. But
It's a little hard to determine what he's.
Yeah, and are you including the septic system in that, or are we just talking about the building?
House, driveway, we haven't even talked about stormwater management.
I think my intent was that the minimum amount of disturbance to the agriculture part of the lot is our goal and our intent.
Because if you were to say, proposed lot 3 and proposed lot 2 would include a septic system and dwelling, but that septic system, dwelling, driveway, et cetera, would take up less than 2 acres of each lot, I don't think a variance is necessary. My interpretation, that's my interpretation of the ordinance, and I think it's not well-written, but, and I'll,
What kind of goes to my thought about this, when we all talked about it the other day. Let's say somehow we could get 2-acre lots here. What you're gonna see out there on that road is, with that or with what he's proposing, is no different. 2 homes on wide open farmland. You're just not gonna see the lot lines. Kind of where you're getting to. You know,
Yeah.
he's only gonna disturb the corner.
I don't think, I mean, I guess this is again, and the board, we can talk about it in deliberating, but my interpretation of the ordinance is that it doesn't require that. If it's an agricultural lot, which can include a dwelling, including a new dwelling, if it's an agricultural lot, as long as the home and septic system fit on 2 acres of that lot, whatever size the lot actually is, as long as that the subdivision doesn't require a variance. And so I guess that's what I'm just trying to clarify, that, because nobody's going to, I don't think, if you have a 100-acre farm, nobody's, well, I can't say that they wouldn't, but subdivide it just to have fields, unless it was going to be an add-on lot to somebody else's farm. That would be not the typical reason to subdivide a farm. But this ordinance clearly allows subdivision of a farm. And my difficulty with this is, if the board says, or determines that this is permissible, this subdivision, or grants the variance, or whatever, what limitation could be put on? I mean, I think according to the ordinance, the limitation is 2 acres. What I'm trying to get at is how much of the property is going to be developed and not be part of the agricultural use. Not because I think that if you say, oh, we could probably fit the septic system and the house on 2 acres, I don't think that means you have to subdivide off 2 acres. I just think that again, it's the board's decision, but my interpretation of it is, and it's confusing, that a subdivision is permissible. You can have smaller agricultural lots, and on those smaller agricultural lots, you can put a new dwelling. The dwelling improvements have to meet the minimum and maximum lot requirements for the non-agricultural use. They should take up no more than that amount of space, which here is 2 acres for residential use. And so if the variance is granted, what is the variance that you're asking for? Is it that 5 acres of each lot can be used for dwelling and septic and improvements? Or, that's I guess my confusion about what, am I making sense? Am I confused?
Well, I think Mr. Spangler was directed to file for a variance because of maybe the original interpretation that this is a 16-acre lot and this is a 30. And I don't, unless we missed the vote on that, but was that your understanding originally?
Yeah, because of the language of the subdivision size.
I mean, I suppose otherwise you would go in and ask for a zoning permit to build a house
In agriculture.
in agriculture, and you could build it. I think that's the reason why you filed this.
Okay.
Okay, are there any other questions, Matt?
Nope.
Okay, Scott, would you like to present the township side.
Well, Mr. Brem cleared up the septic design issue that I was going to bring up. These aren't conventional, small, above-ground, elevated sand mount systems. These are large spray irrigation fields. So it's sort of like a meadow with a sprinkler system. It's not going to be disturbed. The soils are very shallow. That's why it's not approvable for a conventional above-ground system. From the zoning perspective, it's pretty, it's not very clear about if an ag use includes a single-family residence, and you can only have one principal use on each lot. So is it ag or is it residential? If it's, if you're gonna have a residence there, I'd say that the residence is the primary use. And that could only take up, you'd have to abide by that 2-acre rule then. That was my interpretation of it. That's why I recommended that he apply for the variance.
From what I'm gathering, both proposed lots are able to abide by the 2-acre rule, both for the well, the septic, the driveway, and the residence. You can put on 2 acres. So, and again, I agree with your, probably the township's definition of a farm, but there are not very many farms that don't have a residence, that the farmer abides at the farm. Not all cases, but in many, at least in this area.
And the ordinance does have a definition of farm dwelling separate from, other residents. So I guess that's my interpretation of it. Otherwise, it doesn't make sense to have the portion of the, to say that there's no. So, I mean, if the township was just not going to allow subdivision of farm lots, I think it would say that, but it allows some subdivision of farm lots. It just says if you're going to subdivide them just for residences, like Mr. Brame talked about, that we're familiar with in the county, where over the years little lots get subdivided off just for a residence for one reason or another. If you're going to do that, you're subject to certain minimum, maximum lot requirements. But if you're going to subdivide it off large lots for smaller farms, that you're allowed to still build a new dwelling, a farm dwelling, on those new farm lots. But the requirement is that the farm dwelling and accessories to it must meet the maximum lot requirements for the use. For like the residential use. That's how I read it. Otherwise, it doesn't make sense to me that we'd be talking about, I don't know, it just doesn't make sense to have the provisions regarding subdivided. I mean, again, I don't think that there are a lot of farms that are being subdivided just to sell off a 10-acre lot. If a farm's subdivided and there's field, it's usually to add to another farm or whatever. But if you're subdividing like this, you're going to put a dwelling on it. I don't know. I'm confused by any other interpretation of the ordinance because it doesn't make sense to me. I read it to say you can do it. You can take a 50-acre lot and subdivide off a 30-acre lot and put a dwelling on it. That dwelling and the accoutrements should be under 2 acres. And if they can't be, that's where the variance would come in. So.
Okay. Anything else, Scott?
Scott, I have a question. Is there any documentation from the sewage enforcement officer around how these locations were determined and approved?
I don't have that information with me. I'd have to contact the SEO.
Something else?
I just want to add, so looking at that, and here's where I kind of reached that, looking at section 27-505-1B, the second to last sentence, it talks about, with the portion of the existing or newly created lot used for residential purposes, limited to the maximum lot size set forth above. That to me says you can have an agricultural lot that's bigger, you can build a dwelling on it, but the dwelling and stuff needs to fit within the 2 acres, or it would require a variance for some reason. Otherwise, that sentence doesn't make sense to me, I guess, but I'm open to other ideas. But I guess we could talk about, the board can deliberate. Sir, do you have your entry of appearance form? Can you bring that up to us? Thank you. Not 100% what he wants.
Yes.
Is it Collenberger?
And Cowenberg,
Callenberg? Okay. Is that an H at the end?
yes.
Okay.
Could you just spell it for me on the record? Your last name.
See?
How about if I give you my driver's license?
Okay.
It's long.
If you can give it to me, I'll read it because I want to make sure I have it right as well. So it's, all right. And it's Van Callenberg.
Right.
So it's VAN space CAUWENBERGH.
That's my game line.
All right, thank you. That's a good name to learn to spell as a child, I'm sure.
Okay, sir, it's your opportunity to speak or ask questions or...
Well, there's a couple things I'd like to say. I think there's a lot of ifs in this situation. The proposal for number 1, that lot, the septic system, existing septic system, I don't know too much about this new fancy thing, septic system that you're proposing. How many of them are in Huntington Township now?
I don't know. Mr. Scott, would you?
I have no idea how many spray irrigation septic systems are in Huntington. I don't know.
I mean, that's a new one on me. I've never even heard of it before.
I've not heard of them, but we can find that out.
I mean, you're basing this on this septic system and the size of it. But I'm also concerned about lot 1, existing. It's been there for years and years. It's at the low end of the property. Is there any consideration for putting a sand mound or something like that?
We aren't allowed to have jurisdiction.
But you're allowed to make a subdivision of that piece of property without considering it? I don't think that that's too smart. Also, there's a consideration of this lot that's adjusted adjacent to mine, off of proposal lot 3. If they're gonna build in that corner, is what's going to happen to that lot if that gentleman wants to build there? You talked about setbacks. Is that included with your 2-acre proposal? Like when you said about putting in the driveway, the setbacks is going to push the driveway over, isn't it?
Whatever the setbacks at that point,
So,
yes.
so is that gonna increase that, size?
Technically, you can still pasture the setback, and it could be considered,
But see, that's another
agricultural.
if.
well,
I mean-
I'm just stating
But that's
fact.
what I'm saying, this whole thing is on ifs.
Okay.
So
I mean, you
I just
should,
want to clarify here that we're not, this variance is as to the lot size and involves an interpretation of the ordinance. Any development of these lots that is not addressed by this variance application would still have to go through a separate process and be subject to all township ordinances in terms of setbacks and everything else. The issue here was, I think that there's a township interpretation of the ordinance that may or may not be different than the zoning hearing boards, and we ended up with an application, but they still would have to show improvements eventually and submit plans when they go to actually build. And all parts of that development would have to otherwise meet the ordinance and all of the zoning ordinance and all other ordinance of the township. So I guess I just want to stay away from, because I don't think we have that in front of us, or that it's, except to the extent that it's, that I discussed in terms of how much of the lot will be developed, really before us. I don't think that if the board determined that a variance is not necessary to subdivide these lots, that that's granting them carte blanche to do whatever they want in terms of where they develop it.
Right.
But go ahead. I think the board probably understands your concerns, but you want to let you continue. I just want to clarify that.
it's an ordinance and I think it should be upheld.
And that's an interpretation of that ordinance. And our legal counsel is saying that it is being upheld. As long as they don't build on more than 2 acres of the total mass. So.
It's a white piece of property.
I understand that. I farm within
And like I said,
a mile of this.
how many of those systems have you put in the township?
I'm not aware of that. I don't have that information.
And again, we don't really deal with that as a zoning hearing board. Any septic design is gonna have to pass muster in terms of state regulations and go through the township's SEO. I mean, nothing we're going to do here tonight is going to permit or not permit a certain type of septic system. If the system's legally permitted. I'm a little bit familiar with spray irrigation systems because I've dealt with them in other contexts, and I've heard objections to them in certain areas near streams and things. But they are permitted in Pennsylvania and I believe it in the township, so That's sort of out of the zoning purview.
Anything else, sir? Okay. Matt?
I think that's it. Did our other person that expressed maybe wanting to be a party in interest want to give a final answer on that?
Not at this point, it's just a zoning variance, not a zoning change.
Okay.
Mr. Teeter, I have one question. I asked with regards to the section code 27505 1A. So in the middle of that, it says the minimum lot area for all non-farming single-family detached dwelling shall be 1.5 acres, no more than 2. But the other, I'm wondering, even reading that, if that even applies, because it is going to be farmed. It's not going to be a small lot like we saw Mr. Lebo see those small lots that are cut out for not being used. So it is going to be a farm, single-family dwelling on a farm.
I mean, that's my reading of the ordinance, is that it wouldn't include that distinction between a farm dwelling and a non-farm dwelling if there weren't different treatment of it. And it's always been my understanding in most agricultural conservation districts around that, you know, the idea of these limitations on being able to subdivide is just to not end up with like 10-acre estate lots with a 10-acre lawn. And and it doesn't necessarily mean you can't take a large farm and make 2 or 3 smaller farms, as long as it's still an agricultural use with dwellings on each smaller farm. That's my interpretation of it, and I don't think that I understand why we're here and why there's the confusion, because again, I think it's not well written, and I don't mean to insult anybody that had any input into how it is written, because I know the process of writing a zoning ordinance can be very difficult. But it just doesn't make sense to me to include some of these distinctions if it doesn't mean you can do. You know, I think the zoning ordinance permits what's being requested here, as long as the portion for the farm dwelling and it meets the 2-acre maximum. That's my reading of it. And I think what you pointed out is relevant to that.
Yeah, I mean, I don't even know that 2-acre maximum applies, because it seems to carve out that it does apply to non-farm, single-family detached dwellings, but not to farm, the farmsteads, like they're proposing.
Well, in that next section, then it does have, so, I mean, maybe that's inconsistent. It talks about the portion of the existing or newly created lot used for residential purposes, limited to the maximum lot size set forth above.
Yeah, it's confusing, I agree.
Does anybody have any follow-up on this discussion? We could
I don't have anything more.
adjourn to.
Tom?
I'm good.
All right, we're going to adjourn into an executive session and deliberate on this.
And we'll be back.
We will be back.
Do you know?
Okay, I'd like to call this hearing back in order. Do I have a motion that addresses this?
Yes. I move that we dismiss the application on the ground that no variance is required for this proposed subdivision. If the portion of the existing or newly created lots used for residential purposes exceeds 2 acres, a variance from section 27-505.1.b.1 would be required, but there is not enough information presented as part of this application for us to make that determination.
Okay, I will second that motion.
Okay. So you take a vote, even though it's
Yeah. All those in favor of the motion signify by saying aye. Opposed, same sign. So moved.
I would just like to clarify, I think we discussed everything on the record previously, the interpretation of it. So it may very well be that you need more than 2 acres to do your septic system and residence and so forth, but there just wasn't enough information at this phase, and I don't think that's why why this came to us. So it's possible that a variance would be required, but the interpretation of the ordinance of the zoning hearing board is that the subdivision and then the building of residences on these farm lots, which are agricultural in nature, is permitted. That is, to put it real simply, if you had a 100-acre farm and you wanted to subdivide it into 2 50-acre farms and build a house on each, that's permitted as long as the residential portion of the new lots is 2 acres or less. And if it has to be more than 2 acres, then, I guess that would come later when you're further along in the plans. But that's where we are. And I will still, and the board will issue a written decision, explaining further the decision, but it's the board's decision that subdivision can go forward as proposed.
Okay. Any other motions come before the board?
Nothing for me.
All right, this meeting is adjourned.
Thank you very much.
Thank you.